Religious passions cannot be aroused to garner votes. That's the law of the land. But to believe that a clean separation is possible is to ignore the complexities of societies in which the law operates. Since religion is intrinsic to human civilization, especially in a multicultural country like India, would it be wise then to understand secularism from a completely Western lens? Today, we intend to summarize India's tryst with the concept of secularism and how Indian secularism clearly demarcates itself away from the Western brand of secularism. Religion has always been relevant to politics of India. It is an intrinsic part of the political discourse. It brings an emotive pitch for political parties to appeal to the hearts and conscience of voters. Legally speaking, religious passions cannot be aroused to garner votes. That's the law of the land. India, the world's largest democracy, has witnessed an intense, thought-provoking debate on religion and politics in the last few years. Today, we intend to summarize India's tryst with the concept of secularism and how Indian secularism clearly demarcates itself away from the Western brand of secularism. First, to the definition itself. What is secularism? Does secularism mean a complete detachment of religion from the state? If that is so, in what way and in what form? Since religion is intrinsic to human civilization, especially in a multicultural country like India, would it be wise then to understand secularism from a completely Western lens? For the sake of simplicity, secularism can be broken down to its two elementary parts. One, no religion shall be established by law as the official state religion. And two, every citizen shall have the right to practice, profess, and propagate their religion. Most scholars agree that these two basic facets distinguish a theocratic nation from a democratic secular one. But to believe that a clean separation is possible is to ignore the complexities of societies in which the law operates. The journey of secularism and the Indian constitution is rather unique. The term secularism was not originally explicitly a part of the Indian constitution, though the Constituent Assembly agreed on the concept of secularism and the secular nature of the Indian polity. It was not explicitly included as a part of the preamble of the constitution. Later, by the 42nd Amendment, which was passed by the Indira Gandhi administration in 1976, the word secular were added to the preamble of the Constitution of India. However, the Indian brand of secularism is distinct from the Western ideas that surround secularism and has evolved around the unique multicultural history of our country. For example, in England even today, the king and queen must mandatorily be a Protestant Christian and high-level religious appointments are made by the state. That's not the case in our country. No official or state position can be denied or reserved to an individual on the grounds of religion. Indian secularism is in a unique conundrum. For example, most temples in India are administered and regulated by elected governments in the states, but religious appointments are not made by the government. On the other end of the spectrum, personal laws continue to be legal in the absence of a uniform civil code, and the courts are often called to interpret the basic tenets of religion, offering a unique interplay of law and religion. But what have our courts said so far on the concept of secularism? Our courts have always been assertive and on multiple occasions to underline the importance of secularism. In the historic case of Kesavananda Bharti, the Supreme Court laid down that the basic structure of the Indian Constitution has within it secularism. A constitutional structure that cannot be changed by a legislative effort is the basic structure. When the Supreme Court asserted that secularism is part of the basic structure of our constitution, that assertion continued in multiple cases thereafter. In the landmark case of S.R. Bommai, the Supreme Court, when deciding the presidential proclamation dismissing 3 non-Congress ruled state governments in the wake of the Babri Masjid demolition, it declared secularism as the basic structure of the constitution once again. In the subsequent case of Ismail Faruqui, the Supreme Court attempted to provide an Indianized definition to the concept of secularism by referring to ancient Indian texts such as the Yajur Veda, Atharva Veda and Rig Veda. The court gave formal recognition of sorts to the concept of Sarva Dharma Sambhava, largely based on the notion of tolerance. Interestingly, in the case of Manohar Joshi, the court held that the concepts such as Hinduism and Hindutva were not necessarily anti-secular and emphasized on the notions of tolerance. Once again, it clarified that the words Hinduism or Hindutva are not necessarily to be understood and construed narrowly, confined only to strict Hindu religious practices, unrelated to the culture and ethos of the people of India, depicting the way of life of the Indian people. Is Indian secularism then religion neutral or religion averse? In India, the state is secular in that there is no official religion and the constitution does not enforce any religion as the religion of the state, but it guards the right of each individual to practice, propagate and profess any religion and practice their faith. In fact, Article 15 of the Constitution prohibits the state from discriminating against any citizen on the ground only of religion, race, caste, sex, place of birth, etc. But that does not mean that no religious tentacles are found in state practices. The Supreme Court of India's motto, Yatho Dharma Statho Jaya, where there is dharma, there lies victory, is derived from the Bhagavad Gita. Some states have state symbols. For example, the state of Tamil Nadu, which has the symbol of a temple Gopuram as the state symbol. Dharmo Rakshati Rakshitaha is a byline for many governmental institutions, once again derived from the Gita. Cow slaughter is a criminal offense across most Indian states. It's punishable. The law guards the religious views of the majority. In this case, it could be said that by cow slaughter, indeed, the religious beliefs of the majority are being protected. Although constitutionally cow slaughter can be connected to protection of milch cattle. Similarly, various personal laws amongst minorities continues to exist and continues to receive the protection of the constitution despite they being violative of the basic right to equality in most cases. The state through omission has allowed personal laws to exist in a democratic secular country. Similarly, constitutional courts find themselves in a tough spot as they become the final arbiter, often dealing with complex questions of law and theology. The recent case of entry to the Sabarimala temple is an interesting example. The Supreme Court has now referred the question to a larger bench. These questions include the extent of judicial interpretative scope in religious practices and whether the practices that discriminate based on gender or caste can be allowed to exist in an egalitarian and democratic society. Recently, many new anti-conversion laws have been brought into force by multiple state governments that set checks and balances when someone wants to convert from one religion to another. These laws, whilst have been critiqued by many to be infringing upon the freedom of religion in India, is also supported by many on the basis that the secular fabric of the country must be protected. Clearly, the one thing that the debate brings out is that India has moved forward from the colonial ideas of secularism. The shift has been towards a culturally nuanced definition that is unique to India and its cultural identity. But the debate on secularism has just begun. The ambit of personal laws, state protection to the religious beliefs, and the management of religious institutions are all hot topics of debate and of public discourse. Whilst the political statements are best left to the politicians, the law stands clear on the matter of religion. While the courts have fiercely guarded individual freedoms of conscience, the judiciary has also been forthcoming in correcting various social wrongs, especially when the legislature is hesitant to do so. The Indian brand of secularism has clearly shifted to where the state is obliged to guard neutrality in matters of religion when it frames policies and promulgates legislations, but at the same time not be averse to the cultural identity of the nation.